Hello everyone, we are Group 2 and in this video we are going to examine the nature of an affidavit and its relevance in legal proceedings. Let's first define what an affidavit is. An affidavit is a formal sworn statement of fact signed by the declarant called an affiant and witnessed by a taker of oaths such as a notary public. The name is medieval Latin for he has declared upon oath. An affidavit is only valid when made voluntarily and without coercion. In signing an affidavit, the affiant is asserting that the information is true and that they have personal knowledge of the facts contained in the affidavit. They are also stating that they are competent to testify about the information provided if called into court. So what are the purposes of an affidavit? It is to allow evidence to be gathered from witnesses or participants who may not be available to testify in person before the court or who may otherwise fear for their safety if their true identities are revealed in court. And to obtain a declaration on a legal document that the information provided by the applicant is truthful to the best of the applicant's knowledge. If after signing such a declaration, the information is found to be deliberately untrue with the intent to deceive, the applicant may face perjury charges. So what is the legal significance of an affidavit? The most defining trait of an affidavit is its commitment to honesty. The central point of an affidavit is that it is by virtue of its form and signature a sworn oath of truthfulness. False statements on an affidavit will subject the declarant to perjury charges and possibly also contempt of court charges. It is therefore advisable for declarants to carefully read and understand all of any affidavit before signing it. There are various types of affidavits in the Philippines, including but not limited to the following: affidavit attesting to the death of a person, affidavit for cancellation of entries in TCT, affidavit in support of reckless imprudence, complaint for damage to vehicle, affidavit of consent and support for travel of a minor, affidavit of consolidation of ownership, affidavit of death due to vehicle accident for insurance claim, affidavit of declaration of ownership of real property, affidavit of illegitimacy of child, affidavit of indigency, affidavit of loss BIR certificate of registration, affidavit of lost driver's license, affidavit of lost passport, affidavit of ownership of personal properties for contract of pledge, affidavit of support and consent, affidavit of support for PhilHealth, affidavit of undertaking as custodian, affidavit one and the same person. Thank you.
We're now on the topic how to write an affidavit. For us to understand how to write an affidavit, let's first take a look at its parts. First, we have the header. The header indicates the venue where the affidavit was notarized. This is to show whether the notary public has acted within his or her jurisdiction. The 2004 rules on notarial practice provide that a notary public shall not perform a notarial act outside his or her regular place of work or business. This is how header should look like. Now, we often see the two letters S in the header. This is called silicet or subscriptse. It is used to particularize a general statement. For example, in this heading, it says Republic of the Philippines, SS Baguio City. This actually means in the Republic of the Philippines, particularly in the city of Baguio. Next, we have the title. Some notaries public just put the word affidavit, but it's best to write the specific kind of affidavit in the document. For example, affidavit of loss, affidavit of one and the same person, and so on. This way, the person reading the document will immediately have an idea what the affidavit is all about. The next section of the affidavit is what is known as a statement of identity. This section is used to introduce who the affiant is in relation to the facts in the body. It particularly contains the affiant's personal information, such as their name, age, citizenship, and residence address. Also, here, the affiant will state that he or she has been duly sworn to in accordance with law. With such statement, the affiant implies that he or she will tell the truth under the penalty of perjury. This is an example of a statement of identity. Then comes the body. This section of the affidavit is the longest. There is no certain length this section should be, but it's important that it includes all relevant information. The body consists of the facts attested to by the affiant, who should have actual knowledge of the said facts and not merely a belief. The allegation should be full, certain, and accurate. The individual averments must also be numbered as mandated by law, each one making a separate claim. This is an example of a body of an affidavit. Now, the body should include a conclusion generally stating that the statements made therein are true. The conclusion should also state the purpose for which the affidavit is being made. This is an example. Next, we have the signature section. The affiant will affix his or her signature over his or her name following the body. Note that a competent evidence of identity, such as an ID, is placed below the affiant's name. For the affiant, this is the final step in completing the affidavit. The document will be notarized afterwards. That is why below the signature is the jurat. The jurat is an attestation by the administering officer or notary public saying that the contents of the document have been subscribed and sworn to before the administering officer or notary public by the affiant. This is an example of a jurat. Then at the end of the jurat is the notary section. This section contains the notary public's details, such as his or her name, office address, notarial commission date, MCLE compliance number, roll of attorney number, IBP number, professional tax receipt number, and tax identification number. Then, below the notary section are the details about the notarial book of the notary public. The details are usually placed on the left side of the document. So, how do you write an affidavit? Drafting an affidavit is just like telling a story. You make a narration of the events that transpired. To ensure that the affidavit is easily understood, the best practices should be observed. Here are some of them. Keep legal language out of the affidavit as much as possible. Most of the time, the affiant is a non-lawyer. It follows that the statements and averments in the affidavit are in plain English, if not in Tagalog or in the affiant's local dialect. Clarity should be your goal when preparing an affidavit. Try to be factual, not emotional. Just state the plain and simple facts. There may be some instances in which dramatic statements cannot be avoided because they are relevant to the claims made in the affidavit. However, if they do not fully support the claims, it's best not to include them. Next, be specific about conversations. Special care should be taken when describing conversations the affiant has had. The substance of the conversation should be set out. That is, what exactly was said by who and where. Do not include the affiant's impression or opinion about what the conversation meant. Stick to the facts, not opinions or conclusions. The facts should be based on what the affiant knows about firsthand. That means what he or she personally saw, did, or said. Let's take a look at some examples. When your statement is a fact, it should be like this. When he arrived, he smelled strongly of alcohol and was slurring his words. But when it's in the form of a conclusion, it becomes, he was drinking before he arrived at the house. Another example, if you're stating a fact, it should be, the father often cancels his visit to my son. The log I keep shows that this happens about 50% of the time. Our son looks forward to these visits and gets upset for days after his father misses a visit. A conclusion would sound like, the father never shows up for his visits. He is a terrible father who deliberately hurts his child. See the difference? In the first statement, you're just stating a fact. In the second statement, you're drawing a conclusion, which shouldn't be. Example number 3. A factual sentence would be, she was crying when she came to pick up the children last week and the week before. On the other hand, a conclusion would sound like, she needs mental health treatment. More examples. The fact, I had 1,000 pesos in my wallet on the table by the front door. I noticed it was gone after he picked up the children. And then in conclusion, he took 1,000 from my wallet. The point is to describe what happened and avoid interpreting the events. Finally, don't forget to proofread the affidavit for spelling and grammatical errors. Keep in mind that the affidavit may speak to the affiant's credibility. Exaggerations, statements designed to embarrass the other side, or personal opinion about the other side's character will only harm the affiant's credibility.
So how does an affidavit differ from a judicial affidavit? As to use, an affidavit is used to prove the truthfulness of a certain statement of facts. It may be submitted to attest certain facts in court or may be used for other lawful undertaking. One example is when a person is seeking a reissuance of a document or identification card from a public or private office due to loss. With respect to a judicial affidavit, it is a written statement of facts by a witness in lieu of his direct testimony that may be offered in any actions, proceedings, and incidents requiring the reception of evidence. So instead of offering an oral testimony in court, the witness's testimony is taken before a notary public. So the judicial affidavit rule states that this is aimed to reduce the time needed for the completion of the testimonies of witnesses in cases under litigation. As to contents, an ordinary affidavit comprises the following. First one is the header, the title, which may be either affidavit of loss, discrepancy, etc. The opening statements, which includes the private facts, such as the name of the affiant, the age, legal status, and address. The fourth one is the body, the affiant's signature in the jurat. With respect to a judicial affidavit, the following are its contents: the name, age, residence, or business address, and occupation of the witness. The second one, the name and address of the lawyer who conducts or supervises the examination of the witness in the place where the examination is being held. A statement that the witness is answering the questions asked of him, fully conscious that he does so under oath and he may face criminal liability for false testimony or perjury. Questions asked of the witness in his corresponding answers. Fifth one, the signature of the witness. And the sixth one is the jurat with the signature of the notary public who administers the oath, or an officer who is authorized by law to administer the same. As to execution, in an affidavit, the affiant signs the document and is then witnessed, authenticated, and subscribed by a notary public or a person authorized by law to do so. However, in a judicial affidavit, apart from the signature of the witness and the jurat of the notary public, the judicial affidavit shall contain a sworn attestation at the end, executed by the lawyer who conducted or supervised the examination of the witness, stating that he faithfully recorded or caused to be recorded the question he asked in the corresponding answers, that neither he nor any other person then present or assisting him coach the witness regarding the latter's answer. And as an additional penalty, any false attestation shall subject the lawyer to a disciplinary action or disbarment.
So hello, I will be talking about some rules in writing an affidavit. So the first rule would obviously be to comply with the hearsay rule in the rules of evidence, especially when such affidavits are going to be presented as evidence in court, wherein evidence, whether oral or documentary, is only hearsay if its probative value is not based on the personal knowledge of the witness, but on the knowledge of another person or a third person. In other words, the statements of the affiant in the affidavit must be based on his personal knowledge. And then here are some common rules when it comes to writing an affidavit. These are not exclusively all, because there are a lot of affidavits, and there may be some special rules applicable to certain affidavits. So the common rules would be: one, you must always state the circumstances of the affiant. This includes the name, age, legal status, nationality, address, or residency, and any other relevant information necessary for the affidavit. And then the narrative. These are the circumstances surrounding or statements relevant to the subject of the affidavit. For example, in the case of an affidavit of loss, the affiant must describe the object, his relationship to the object, when did he last use or see it, and the efforts he took to look for it, and any other information or statements which may be relevant to the affidavit. And then it is also necessary that there must be a declaration of the affiant that the statements he made in the affidavit are the truth. And then we have the last two, which are also necessary: that the affiant must sign the affidavit, and that there is a duly executed jurat. These two requirements are to be made in accordance with the 2004 rules on notarial practice, wherein the affiant must appear in person before the notary public and present the instrument or document, in this case, an affidavit. And then two, the affiant is personally known to the notary public or identified by the notary public through competent evidence or of identity. And then the affiant must sign the instrument or affidavit in the presence of the notary. And then the affiant takes an oath or affirmation before the notary public as to such instrument or document. So we will go over these rules one by one and discuss the rationale behind them. So the first, must appear in person before the notary public and present the instrument or document, or in our case, an affidavit. So the purpose for this is for the establishment of the identity of the affiant. This is in connection with the second requisite. Appearance before the notary public is very much necessary because in a lot of cases, a lot of affidavits and even some notarial documents have been deemed inadmissible for failure to comply with this requirement. And then two, is personally known to the notary public or identified by the notary public through competent evidence of identity. So what are the competent evidences of, competent evidence of identity? So as provided in the rules on notarial practice, section 12, there must be at least one current identification document issued by an official agency bearing the photograph and the signature of the individual, or the oath or affirmation of one credible witness not privy to the instrument but personally known by the notary public and the affiant, or the oath or affirmation of two credible witnesses, neither of whom is privy to the instrument, who each personally know the affiant and shows to the notary public documentary identification. The same with the first one. So, and then moving on, number three, the affiant signs the instrument or document in the presence of the notary. This is to make sure that the document signed by the affiant is the same with the document presented to the notary public, because there have been instances wherein there was a change in the document signed and presented. So, and then the fourth would be takes an oath or affirmation before the notary public as to such instrument or document. So the rationale for this is it makes sure that the statement of the affiant are true, because if what the affiant said is later on proved to be false, then the affiant may be prosecuted for the crime of perjury. So that is all. Thank you.
Good day, everyone. This is Group 2 for Affidavit. Question number 6. How do you introduce an affidavit in a judicial proceeding? Please take note that the affidavit mentioned for our group is not the same as the judicial affidavit in court, which is why the Judicial Affidavit Rule, or AM number 12-8-8-SC, will not be mentioned in this case. So, to answer the question, we go to pre-trial. In pre-trial, the affidavit must be marked to be called up as evidence in the course of the judicial proceeding. During trial, the witness must testify on the contents of the affidavit in the witness stand. A document, in this case an affidavit, may be offered as object evidence or documentary evidence depending on the purpose for which it is presented in court. It is object evidence if the purpose of its presentation is to prove its existence. In contrast, it is documentary evidence if the purpose is to prove the contents of the document. However, in either instance, a document presented as evidence requires identification by a witness. Thank you for listening. This is Group 2 for Affidavit.